Hi everyone, it's David Thronson, and I'm here with Veronica Thronson, and we have Leslie Orloff and Alina in Rocio in Texas, and are going to do a broad overview today of immigration law. And hopefully, if you have questions as we go, please ask them. This is a chance to sort of get a lay of the land in terms of what immigration law looks like. As we move forward with the project, we'll be talking much more in detail about how family courts are involved in the process, how the decisions that are made in state courts, whether they're criminal or whether they're family or whether they're juvenile, have impact and import in the immigration system. But we thought before we get to that, which is really the focus of our April kickoff conference, we should have just a broad overview of what immigration law looks like, what some of the institutions, decision makers are, what they, who's deciding things, where are they, what are all these different agencies, and we talk a lot of alphabet soup in immigration law, try and sort through some of that, and just have a broad sense. So we're going to think not so much today about how the state courts are involved, but how the immigration system itself works and what's happening and what's the process that immigrants go through to come and get lawful status here in the United States.
David, before you start, this is Leslie Orloff. I also wanted to welcome all of you to this first of what we hope will be many webinars in a, I guess you could call it a community of practice that is going to be among the judges who are participating in the Judicial Training Network. So I welcome you all here today and turn it back over to David.
Great. Thank you, Leslie. So we have a lot of different agencies involved in federal immigration adjudication. We start really with the Department of Homeland Security is our agency, and it's got three main components that deal very distinctly, and we'll break this down in a minute, with immigration law. We also have the Department of State involved. Traditionally, immigration law was a Department of State issue. People were overseas and they were seeking permission at embassies and consulates to come to the U.S. It's become a much more domestic affair. But in addition to those principal agencies, we also have the Department of Labor involved as we think about employment-based immigration. We have the Attorney General, Department of Justice involved through its various entities. Below that, we have the Executive Office of Immigration Review, which oversees our immigration courts and oversees the Board of Immigration Appeals. The other BIA, it's not the Bureau of Indian Affairs that often gets confused with that. And then we have some labor hearing offices. The immigration courts are administrative law agencies as we get into that, and we'll talk a little bit about what that means as we go forward. So the first one we want to break down a little bit are the three component parts of the Department of Homeland Security. The first we always refer to as USCIS. For reasons I'll explain in a minute, it's the only one that gets the U.S. in front of it. Citizenship and Immigration Services. This is the place where a lot of petitions, a lot of requests for various types of immigration benefits are processed. In some ways, I think of this as the DMV of immigration as we move forward. It's the place where you're applying for something that you think you're eligible for under immigration law, and they're adjudicating those petitions. That means that a lot of our decisions are made outside of immigration court by USCIS as we're moving forward, and then those decisions are imported into the court system as people are moving forward. The one that's in the news most often is ICE, Immigration and Customs Enforcement. They have responsibility for interior enforcement. This was originally called the Bureau of Immigration and Customs Enforcement, and they decided that ICE was a much cooler name than BICE, so they dropped the B in Bureau. We got legislation to move that through, and they've become ICE. This is the law enforcement side. This is the group that would show up in courthouses, would show up outside of courthouses, would show up in communities and make arrests, and is also importantly in charge of overseeing detention. So they are the decision makers often as to whether or not someone is detained or whether someone is released into the community while they're moving their way through the immigration process. So we've got ICE as a prominent player in our system here. ICE also has attorneys who represent the government in deportation proceedings. So whenever there is a removal proceeding where someone is being charged with being removal from the United States, there's an attorney from ICE who will be in the room representing the government there. Customs and Border Protection, CBP. This is our largest law enforcement agency, and every round we get, we're looking to hire more, and they're always pushing to ramp this up a little bit, whether we get a wall or not. They're looking always to hire more CBP officers. They're most prominent and most pictured as at the southern border, as people patrolling the southern border and out in the desert and picking up people who are coming across that way, but also at any other point of entry to the United States. So that can be the bridge from Detroit over to Canada here in Michigan, or that can be an airport in Kansas City. Everywhere you've got someone entering the United States, you've got Customs and Border Protection folks here. In addition to that, they have jurisdiction within 100 miles of a border. And most people in the United States, almost, I believe 80–90% of people in the United States live within 100 miles of a border. If we think of our sea borders and our coasts, and the state of Michigan is entirely within 100 miles of a border because we have the Great Lakes surrounding us. So we have different ways in which they can be involved in what we might think of as interior enforcement in ICE, but because they're near a border, we get different experiences with them. When someone is being removed, they go before our immigration court system. And in a somewhat unique situation, immigration adjudication used to be in the Department of Justice entirely. And when the Department of Homeland Security was created, they moved the functions we just talked about over to DHS. But they left the immigration courts and they left the immigration appeals with the Department of Justice, where immigration had previously been. And that means that our immigration courts, we have immigration judges. It's a very formal setting. Judges wear robes. They're in a courtroom that looks a lot like the courtrooms that we're all familiar with. But they're technically attorneys hired by the Department of Justice, akin to an administrative law judge. Appeals from the various courts. Immigration courts are scattered around the country. In not every state has one, but every region has immigration courts, and then a lot of the immigration courts now are located within detention centers, so that if someone is caught and arrested and detained, their entire proceeding takes place within the facility. The Board of Immigration Appeals is a national body. It's found in Virginia, but it hears appeals from all over the country. And the decisions that it issues are binding on the immigration courts throughout the country. Appeals, in a typical administrative process, appeals from the Board of Immigration Appeals generally go to the various Circuit Court of Appeals. What this means is, one thing that makes our life more complicated is that the BIA may be overturned for some decision or process that it issues nationwide, but it may be overturned only for that circuit. And unless we have circuit conflicts that are resolved by the Supreme Court, it's entirely possible that someone is in a position where they are eligible for relief in one circuit, but they would not be eligible for relief in another circuit, and we have to keep that straight as we're going. The other thing to keep in mind is the proceedings before the Department of Justice, and I'll talk more statistically about what this means, but there's no right to appointed counsel. All of these proceedings are civil. So despite the fact that someone is detained often for many years in essentially actually a prison, in those settings, and the stakes are quite high for people who are in the United States and threatened with removal from the United States, these are civil proceedings, and there is no right. You can bring your own counsel, but you will not get appointed paid-for counsel as you're going forward, and that has some serious consequences for our system. With all these agencies, and please, don't try and trace through this chart. I just throw it up kind of for the shock value of looking at it. This is actually a simplified version of what it looks like for a young person trying to navigate this system. Because even if we're in an immigration court, we might have to stop that proceeding and go over and get some findings from state court and take those findings and go to USCIS, and we might have decisions being made by ICE about custody. And as you move through this whole process, lots of different players in lots of different places are getting involved.
And just a note, this is Leslie, when ICE makes decisions about custody, it's not anything related to family law custody, even if they're making decisions about where they're putting children. So it's a different custody determination than what's normally done in state court.
Absolutely. So this is a system where it matters if you're a U.S. citizen or not. As we think about the world of immigration law, it divides the world into people who are citizens and people who are not. So when we're speaking of citizenship, these are people who just fundamentally cannot be ordered deported from the United States. Anyone who's not a citizen is potentially deportable from the United States, even if they have some status and have been here for quite a long time. Citizens, again, have full rights to participation in our political arenas. They have some advantages as we get into immigration systems of who they can bring to the United States and who they're allowed to sponsor for immigration benefits. So it matters if you're a citizen. So it's worth a few minutes for us to think about how do you become a citizen? Who are the citizens that are out there? The easiest way to become a U.S. citizen, if you plan ahead, as I apparently did, is to be born in the United States. And this is the constitutional protection that we have, born or naturalized in the United States, are citizens. This covers all 50 states. It covers Puerto Rico. It covers the Northern Mariana Islands. I say usually on the slide because we have, there's some timing issues as to when that becomes apparent. So some of our folks who were born earlier might have some gaps or other things we'd have to straighten out, or Guam. And then we have a thing called nationals, who are like citizens except they don't have political participation rights, from the American Samoas, from the Swains Island. And regardless of what you may hear, if you search this on the internet, you will find tons of theories and lots of people saying, well, it matters who your parents are, or children born to people who are undocumented don't qualify for this. The 14th Amendment doesn't cover them. It's just settled law. It's just absolutely settled law that anyone born physically in the United States is a U.S. citizen, regardless of the status of their parents, as we're going forward. Now, that means anyone else who's a citizen at birth, we're doing it via statute, because the 14th Amendment only speaks to people who are born in the United States physically. So as we look forward here, we see that most people who are born abroad to U.S. citizen parents are U.S. citizens. The parents are able to pass that citizenship along. There are some limitations on that for people who are U.S. citizens but didn't live in the United States at any point. Usually it's 5 years that they need to have lived in the United States, and some of that after age 14, so that we're not passing along U.S. citizenship for generations for people who've never set foot in the U.S. or never lived or been here with any connection. This can get complicated with the date of when some people were born. Citizenship statutes tend not to be retroactive, and so when we shift and move, we have to look at what was the law in place at the time it happened, and sometimes with some of our older people that can become important. The last major change was in 2000, so people born after 2000, and now we're getting to the point where if we're talking about children, they're now adults or verging on adults. in that sense, we've had that big change. We also have some rules that say children can become citizens when their parents naturalize. They're able to follow their parents through the process. Importantly, this has to happen before the child's 18. It has to be a child who's a lawful permanent resident. So it has to be a child who's here lawfully and in the legal and physical custody of parents. So already we're seeing some ways in which decisions about who's a parent and who a child lives with have impact on even basic things like who becomes a citizen and who does not as we move through. The third way, if you didn't cover one of these statutes at birth, if you weren't born here, you have to go through a naturalization process. No one becomes a citizen without first getting a green card, meaning they become a lawful permanent resident. You don't get to skip that step. So whenever you hear, she married a U.S. citizen, so she's a citizen, it's just not true. Doesn't happen. We've got to go through a process where someone becomes a lawful permanent resident, and then we have to meet certain requirements. And I'm not going to talk through all these. They're on slides, and people can look at them when they want to. But generally, it's a process that takes 5 years from the time that they become a lawful permanent resident, or 3 years from the time that they become, if they're married to a U.S. citizen. For that.
This is Leslie. The one thing that I'd like to just emphasize is for people who are applying through this process through family immigration, they generally don't get to file their own application. They have to be sponsored by someone else, and that in domestic violence cases in particular can create a power control dynamic that we'll be certainly talking about in a lot of the future training.
And we're going to get to that in a minute, right?
Okay.
So, yeah. So statutorily, if you're not a citizen, you're an alien, right? This is the term that our statute uses. I tend to not use this term. I tend to say non-citizen. Alien has taken on its pejorative, effect in the country. It's almost always used in conjunction with a term like illegal in front of it. But alien really just means any person in the world who is not a citizen or national of the United States. So this includes people who are lawful permanent residents who are in the United States. Technically, they're aliens. They might have lived here for 30 years. They're an alien. Having U.S. citizen children, having a U.S. citizen spouse, you're still technically an alien. And it does include people who are unauthorized and don't have permission to be in the United States. These are the folks that we often hear described as illegal aliens. We'll hear undocumented. I think a growing movement is to think of them as unauthorized. Undocumented turns out to not be particularly descriptive. People have lots of documents. They just don't have a document that says they have permission to be in the United States at this particular time. So people who are here without permission are in that group of aliens, but so are lots and lots of other people as we go. So just a quick overview of what's our immigration population look like. 43 million out of our population of 320 million. People are immigrants in this United States. 13%, that's verging on historical highs. In the 1920s, we tapped out slightly over 14%, so that's historically very high. Most of those people go through the process and become U.S. citizens. So they are still counted as immigrants. They immigrated to the country. They're foreign born. They're part of that 13.5, but 49% of them in 2016 had become naturalized citizens, and from that group, more will as they go. So over time, we're replenishing on the front end with new immigrants, but we're also seeing lots of people move through the process to become citizens as we go. Children of immigrants are everywhere. 26% of children under age 18 are, children of immigrants. Now that doesn't, most of those kids are citizens, and most of them were born here. Many of them, my child is considered part of this because Veronica was an immigrant. She's now a U.S. citizen, but she, Emma comes from a family that is immigrant. So there's a lot of variation as to what these families look like, but we do have lots of kids coming through the system who have a connection to immigrant families, and that's something that pops up a lot as we go. Just because Mexico always is thought of as the country where everyone's from, turns out about a third of our undocumented population is from Mexico. Lately, there's been net negative migration with Mexico as more people are leaving the United States for Mexico than are coming, and that includes often U.S. citizen children who are leaving with immigrant parents as they go back to Mexico, and that U.S. citizen child is leaving the United States with a parent as they come. So we do have a large undocumented population. It's been shrinking slowly. I used to say 12 million. Some of the best estimates, and I think this source is one of the better sources, says we're down to just under 11 million, so I tend to use an 11 million number. Now, of course, there's estimates in this, but they're fairly statistically sound as to how they go about determining this and what we think about. They get here in different ways. A little over half now are people who came to the United States and just stayed. They were on some form of visa and they entered lawfully and just didn't leave in time. And then we have other folks who have crossed the border, usually at the southern border, and come across without inspection. Unauthorized immigrants includes people who are in the process of regularizing their status. So there may be people who are counted among those who are unlawfully present, who are in the process of applying and having something adjudicated for them, or they're in court where they're seeking immigration relief, and some of those undocumented individuals are going to end up entering the lawful side of practice. It's become a very stable population as we've made the border more and more difficult to cross in the South, so that if we look at this, 66% of undocumented population, the unauthorized population, have been here for more than 10 years. It's 78% for Mexicans. And so it's just a very striking sense that folks are unauthorized, but that doesn't mean they just got here. It means often that they're almost a full generation into life in the United States. So now, we said to become a citizen, to not become part of that unauthorized crowd, you've got to become a lawful permanent resident. So, want to walk through what are the ways that someone becomes. Now, when we hit our conference down in April, we're going to talk about a lot of the ways that the family court is involved in some of the aspects of getting this. Today, we want to talk just about what's the general, Immigration 101, how does someone become a lawful permanent resident to the U.S., how do they start this? It's an important process because you're never going to become a U.S. citizen if you don't first become a lawful permanent resident. And it never happens automatically. So having a relationship, having a child, having a spouse is never going to do it. It's a process that has to go through, and in some cases it can be a fairly complicated process to do this. Lawful permanent residents day-to-day look an awful lot like citizens. The idea is that they can stay here permanently unless they do something subsequent to their getting here that causes their status to be rescinded, unless they leave the United States in some way. If they abandon their status, they're not quite as secure in what that would look like. Some strange things can happen for about 2 days last year when President Trump issued his first travel ban that wasn't very well crafted. It technically rescinded even the lawful permanent resident status of every person holding a green card from 7 countries. And they fixed that because that wasn't what they intended even when they were trying to put in a travel ban, but it just showed that sense that until you're a citizen, you're not entirely secure. Lawful permanent residents are given a card to show that they have status. It's something they renew every 10 years, but their status doesn't go out of, it's always good. It's permanent, and unless they're ordered removed from the country. They're just going to need to go through a process under which they can do this. The green cards are green again. I've seen in my practice time 3 different major revisions of the green card. One was beige, one was sort of light greenish in parts of it, and now they're kind of more prominently green in the card. They're cards that are hard to copy. They're, every revision gets a little more serious with its biometrics and trying to figure out how to make these counterfeit proof as they go. Other things that people have often, Social Security cards don't mean much of anything immigration-wise. You might or might not have a Social Security card and be able to work, even if you're a student or some other status. So it doesn't tell you anything per se. It often will have this valid for work only with DHS authorization language on there, and that tells us that we're looking for an employment authorization document, which people in some immigration statuses are permitted to get, but not everyone. Tourists, for example, cannot get an employment authorization document. And this EAD, this document, always comes from the immigration status. It's always linked to that. It's not something you can apply for independently. So how do you get a green card? There's 3 major avenues under which you can do this, and one of them is always on the legislative chopping blocks every time we talk about this. So first one is employment-based. We're not going to have a lot to do with that here with the work we do, but it tends to prioritize people who are with advanced degrees, who are professionals, who have extraordinary ability, who have special skills and training, or people who have money that they are coming to invest. Unskilled workers are not prioritized a lot, and we see a disconnect between immigrants who are actually in the country holding jobs and working, who are not able to use an employment-based system to get any movement in their immigration status because those don't align particularly well. We have the diversity visa lottery. This is the one that's always on the chopping block. If we ever get any immigration deal in Congress, this will go away. Getting rid of the diversity visa lottery is something that will happen. The original idea of this was to diversify where people are coming from because, as we'll see in a minute, family is the major force in our U.S. immigration system, that having a chance for people who have skipped a generation or where those chains of family have broken to restart. This was actually designed to be a jump start to European migration. The first version of this was referred to as the Irish sweepstakes. And it's worked in part to say, what are countries of low immigration? These have tended to be countries in Africa, the smaller countries in Asia, not China, not India. And 50,000 visas are divvied up, and people who meet certain qualifications who win the lottery are then able to come, and then that provides new pathways for immigration from a more diverse set of countries so that we don't have all of our folk coming from the same countries as they come. But the real action in immigration law is family immigration. We have a variety of categories, and I'm going to just run through them real quick as to what they look like. We have a category we call immediate relatives of U.S. citizens, spouses, children under 21 who aren't married, and parents. And for this group, we don't have any numerical limit. Anyone who is a U.S. citizen who has a relative who qualifies in one of these categories can file for that person, and we'll talk about the petitioning process here in a minute. But as they do this, they're not numerically limited. There's processing time. This can take many months, but it's because of bureaucratic delays, not because we have any backlogs. Then we have 4 categories of immigration here in which we have numerical limits. We are set out for a certain number every year. We skim off the top of that how a certain number who go to the immediate relative category, the immediate relatives of U.S. citizens. And so we have a category for adult sons and daughters of U.S. citizens. We don't call them children anymore. We say sons and daughters. If they're unmarried, they're in our first preference category. If they're married, we put them in the third preference category down there. And then the fourth preference is siblings of adult U.S. citizens to go there. And then our second preference stands out because these are more the nuclear immediate family situations, but our relative who's in the United States is a lawful permanent resident, someone with a green card rather than someone who is a U.S. citizen as they move through that. And we have a certain number of visas every year. By formula, they get spread out across this system. And with that, we get a system where people can go through and petition for a relative. So if you're a U.S. citizen or you're an LPR, you can file a petition with USCIS on behalf of that relative. And that makes you the petitioner, and the person who's coming is called the beneficiary. And when you do it, we give you something called the priority date that we lock in, because there's going to be a wait, because all of these kind of systems are backlogged. And as Leslie mentioned earlier, what's really significant about this system as it's designed is that the petitioner is always the person who has the power here, because they are choosing to petition for that relative who qualifies. They're choosing to say, I'm going to use my status as a U.S. citizen or an LPR. And that's why, as we'll talk more in April, we have some opportunities for people who are victims of domestic violence or crimes to get through that. Okay, so when we petition for a relative, if the petition's approved, and this just means they looked at it and said, yes, I'm a U.S. citizen, and yes, I'm really married to this person, they'll approve that petition, and then we watch for that priority date. And we watch, and the Department of State goes through and calculates how long it's going to take and what's going to happen month to month with these different categories based on those numerical limits. And as they go forward, we get backlogs. And they put these out in a visa bulletin. So right now, for example, the second preference visas, these are the spouses and children, nuclear family of lawful permanent residents. This month, they're now issuing visas and saying it's okay to come for people who filed back in March 2016. So it's almost spot on a 2-year wait for those people to come. So if we think about that process, that's historically not bad. There have been times in my life when that wait has stretched out over 5 years for people to come. There have been times when it's been a little bit better. But it's a process that takes time and contemplates families being apart for a long period of time, which puts pressure on people to skirt immigration law in some cases, or to try and wait out in unlawful status while they're trying to get through this process. These can get really long for some of the other categories. The second preference, which is the adult children, unmarried adult children of lawful permanent residents, they're now processing people who filed back in March 2011, 7 years ago. And we've got people, from Mexico. We've got limits per country so that no country gets more than 7% of any particular category. And because Mexico's our nearest neighbor and there's a large demand for these visas, they're backed up all the way to 1996. So people who filed in 1996 are just now getting a visa in this category. The most backlog one we have is the fourth preference, siblings from the Philippines, and we're talking about people who filed in 1994 are now getting there. So we've got a system that's got some significant slowness and backlogs. The other thing that we see with family is that anyone who gets an immigrant visa to the United States can generally bring along a spouse or a child under age 21. So if someone gets an employment-based visa, they don't have to leave their husband and children behind. They can come to the United States and bring them along with them. We also have these for many temporary visas, student visas, visas for exchange programs, visas for sort of temporary work status on these. And in some of these, an issue that we see a lot is that ending formal relationships, like a divorce or a child aging out, can result in loss of status, because if your status is as a derivative, if you cease to have that relationship that created the derivative status, you are going to lose where you're at. So everything we've been talking about is on the sort of positive end. Who's eligible to come? Who can get a visa? How does that work? What qualifications do you have? So once we get that pool, then we turn and we look at that intending immigrant and we say, well, you might be married to a U.S. citizen, that's great, but if you meet certain criteria, we don't want you anyway. And we have grounds of inadmissibility that apply. So we can say, for example, yes, we agree that you're married to a U.S. citizen, you're eligible for a visa, but you're a drug dealer and we don't want you to come here, to this country. Some of the prominent grounds that come up are people who are likely to become a public charge, who have significant health issues that might be contagious, or the language that's used is a disease of public health significance. We have national security grounds. We're not going to allow terrorists to come. We're not going to allow people who we think will threaten the country. We also have some ideological grounds when we say that someone who is a believer in the communist ideology is not going to be permitted to come into the United States. Now, once you're here, we have freedom of political thought, but we're going to deny entrance to a lot of people based on that. So we have also a significant category for people who have prior violations of immigration law. Once they've sort of fallen into that group of people who violated immigration laws, often difficult, if not impossible, to crawl out of that as we're going forward. So just to highlight a couple of these,
David,
likely to be, yeah.
Can I just ask you to elaborate on something for a minute? When you're talking about prior violations of immigration law, you're not talking about just somebody who's here under unlawful status, right? You're talking about some of the more, like somebody who's been removed and then re-entered, things like that. Right?
Well, we're talking about both, right? So unlawful presence, depending on how someone entered the United States, is often a killer for people. So we have this kind of sneaky rule that people who have been unlawfully present in the United States for more than 180 days are inadmissible for 3 years. And a person who is inadmissible, who's been unlawfully present for more than a year and leaves the United States, they're inadmissible for 10. And this becomes really tricky because often we don't allow people who entered the country unlawfully to do any of their processing here, and they're forced to leave the country to process. The minute they leave, they trigger a 10-year bar to coming back in. This is a provision we put in place in 1996, and if we look at our undocumented numbers, we see a fairly significant spike coming up after that as we get people who make a choice if they're with here and they have a family in the United States, and they say, I am not sure that I want to take that risk that I'm going to leave the United States and be away from my family for 10 years before I'm permitted to come back. Now, there are some waivers available for this. They're not easy to get. They're easier to get, and we'll see this in April for people who have domestic violence or otherwise are victims of crime and have those experiences in their life. But for a lot of people who don't have those situations, we have, when we look at that huge portion of the undocumented population who've been here 10 years or more, many of those people are married to U.S. citizens, they have U.S. citizen children, they've got connections here, and they are eligible for a visa. But because of this provision in particular, there are millions of people who have made the choice to stay unlawfully in the United States rather than risk leaving and trying to re-enter. Certainly, if you have more serious violations of immigration law and you've been ordered deported in the past, or you have not shown up at immigration hearings in court, and those can be complicated also and cause this. If you've committed fraud in the past to get immigration status, all of these things can move through. I wanted to just touch on the public charge ground. When we're talking about family immigration, we require that the petitioner be able to show that the family, as it will be constituted when the new immigrants show up, can be supported at a level of 125% of the poverty level as they go through. And that becomes, for many people not a barrier, but for many people that can be significant. So if I'm here and sponsoring a spouse with 2 children coming to the United States, we're talking about being a family of 4. That's $31,000 on this year's charts that I need to be able to document that income, and that's certainly a level that's challenging for many of the people that we see in family court and other proceedings. So we can't talk about immigration without talking about people being deported. We've talked about how you get here, some processes through which you go and get legal status, but we also have a process where people can be removed. And now we've got messy terminology on this. Since 1996, we changed and we decided we don't deport people anymore. We remove people. And we remove people for 2 different reasons. We remove them because they haven't been admitted to the United States and they're here unlawfully and they were never admitted. And so we apply grounds of inadmissibility to them. But we also deport people who have been here, who were admitted, who did something that makes them deportable. So we talk about deportation grounds as a way to remove someone. So people without lawful status who haven't been entered into the United States, they can be deported simply for not being here lawfully. It's a very easy case for the government to make. They say someone is not a citizen of the United States. They don't have lawful permission to be here right now. They've made their case. Usually people who have been admitted with some lawful status, you have to show that something else has happened, especially if they've maintained that lawful status, if they're a lawful permanent resident, in order for them to be deported. Between these 2, you would rather fall under the grounds of deportation, which are a little more difficult to meet for proof against you, as opposed to the grounds of inadmissibility. This gets really tricky when we see people being deported for criminal offenses, because it's harder to deport someone for a criminal offense than it is to find them inadmissible and removable for that purpose under the grounds of this. And so sometimes you can look at it and you can't tell by how long someone's been here. There might be someone who's entered the United States without an admission. They came unlawfully across the border and they've been here for 10 years. They look an awful lot like the person who was admitted and overstayed, but we're applying a different law to them that's a little, more stringent for the folks who haven't been admitted. So, what are some of these things that get you in trouble? Crimes involving moral turpitude, which sounds like an awful thing. But a crime involving moral turpitude is often any crime that involves theft or anything that's fraud related. So shoplifting, for example, is a very common crime involving moral turpitude. And it's a process that we look at it and it sounds fairly awful, but it might involve really petty and small offenses in these cases. Convictions for drug offenses. Really any involvement with drugs is just really difficult to get around in the immigration context. And that can be, possession for personal use of, small amounts of marijuana can be enough to get someone in trouble with immigration. It doesn't matter if you're in a state that has legalized marijuana use, for example, because that's a state decision, but there's still a federal law that's being violated, and the federal government may, or now with Jeffrey Sessions, may not agree not to prosecute, but for immigration purposes, you're still doing something that's in violation of federal law, and that's going to be a problem, even if the state chooses not to go after that. Domestic violence is a ground of deportation. In a weird drafting quirk, it's not a ground of inadmissibility, and that difference highlights a little bit some of the strangeness of which grounds you find yourself under, and part of why it's complicated when people are thinking hard about how they are proceeding through an immigration, through a criminal proceeding when they have immigration issues hanging over their head. But the fact that you're deportable doesn't mean we're actually going to remove you from the United States. Many of the types of relief that we seek, and almost everything that we're going to be talking about in April when we talk about the ways in which the family court is involved sometimes in helping to establish eligibility for different forms, often come up as relief to orders of removal and orders of deportation. So you might have a proceeding where the government meets its burden quite easily of showing that you're here without authorization to remain in the United States. But then you turn around and say, yes, but I am eligible for asylum. I meet the definition of a refugee, and you cannot send me back to a country where I will be persecuted. I meet the qualifications to be a special immigrant juvenile status. I'm a victim of a crime and qualify for a U visa. These are all things that we're not going to really touch on at all today, but these are things where we'll really focus in. But the way they fit in often to the system is that they can be a way to overcome a removal proceeding where you are removable, you are here, and you've either done something that makes you deportable or you didn't have permission to be here in the first place, but then these forms of relief from immigration kick in.
David, this is Leslie again. I also want to add, as to crime victims, they're people who are would have to be sponsored by a family member or an employer, and it gives them a direct avenue to immigration status as a crime victim without the knowledge or sponsorship of that sponsoring person that would otherwise be required.
Yes, that's absolutely right. That our major avenues to getting status all involve that sponsor, whether it be an employer, whether it be a U.S. citizen spouse or parent. But then once we get into these humanitarian forms of relief, we look at people applying directly and being able to circumvent that system and apply based on their own experience as to what's happened and what that looks like. I mentioned earlier that in immigration court, we don't appoint counsel for people. It's striking as we look at statistics of what that means. 37% of immigrants had legal representation in their removal cases. If you're detained, and we put our detention centers in really hard to get to places often where we're outside metropolitan areas and where it's really difficult to figure out how you're going to work as an attorney to get out there and work with your client and be ready. We only see 14% of people having attorneys. And so, the vast majority of people going through this complicated immigration court system don't have attorneys to help and guide them through. That carries over to kids. We don't promise children that they have lawyers. So we see, and this group here, Transactional Record Access Clearinghouse, TRAC, is really the best source of any data regarding our immigration courts and what's going on there. And they've tracked cases through time, and for cases that were started in 2015, 3 out of 10 kids still don't have a lawyer. And cases have been drug out and they're not resolved yet. And we see for newer cases where they haven't had opportunity, 3 out of 4 cases don't have a lawyer. 25% of kids are initially represented in proceedings. So with all these complexities and all the different types of issues that we have going on here, we just really don't have lawyers playing in, and we have terrible time for people to try and figure out, how does this relate? Should I be filing at USCIS? Am I filing in immigration court? What different types of timing is important? What kind of documents do I need? Really tough to do without attorneys here. And it shows in the results, right? You're twice as likely with representation to get relief for people who sought it. Really just 5 times as likely if you're detained to get relief if you have counsel than if you don't. If you're detained and you don't have counsel and you don't have access to information and people able to communicate with you as to what's going on or your own documents, it's a fast track to deportation as we go through there. So this is really the kind of big picture, and I talked really fast and went through this, fast to try and think about terminology and who we're talking about and what's happening. So chance here to chime in with questions people have, or if they don't, we'll take a minute and talk a little bit about a listserv we have coming up and some other things to think about. So we'll give a minute here and see if anyone wants to chime in with any questions.
And you could type your questions in the chat box, or Alicia can unmute your microphones and you could ask them over the phone.
Is the PowerPoint going to be available? Yes, I believe it's available now. On my screen, I see it in kind of the lower right-hand corner there. But if not, we will also have this whole presentation taped and with the transcript and with the recording. Alicia is going to put that up. And so Alicia says, yes, it's available for download right now. So the PowerPoint is available. And then, Alicia, you're going to send us a link, is that right, for the presentation itself?
Yes, the recording will be available as well.
Be available. And just so you know, we've talked. This is Alicia's at the National Council of Juvenile and Family Court Judges, who give great support for this. We're going to put this behind a password for all of these as we think about this as the first of over the years many conferences like this. That this will be password protected, which means if people are asking questions and going on, it won't be something the general public can get into and look at and say, gee, Judge so-and-so from this place asked this question, what's that say about his thinking or her thinking, and how do we go about it? This is internal and protected for our group, so that this is an internal conversation.
Right, and that means that on these webinars you can ask questions, and eventually we'll have it set up so you can actually talk with each other about issues that we may be raising or talking about that might be arising in your states where you want to learn from each other in addition to learning from presentations. So what will happen is there'll be a password protected location that will have this webinar and the PowerPoint. It will also have future webinars in the PowerPoint all in the same location. I think we could also, David, distribute to with the link an actual PDF copy of this webinar as well to the people that are on our list of judges for this project.
Absolutely. Yep. That's easy, and we can do that. Veronica, do you want to talk a little about the listserv that you've set up?
Yeah, so we have set up 2 listservs, and we'll send you an email with instructions. One of them is going to be for everyone involved in the projects, and that involves the nonprofit community organizations that are providing support in each state. And the other listserv is going to be for judges only. So I'm going to be sending an email either later today or tomorrow with instructions, and it's going to be housed out of MSU.
Right, and then when we meet in April, we'll talk about which or both with listservs, the court staff, the people that are the partners that are working in state agencies or working at the courts, whether they're on one or both of those listservs, but we'll talk about when we meet in person. That's Leslie.
Good. Well, we're close to on time. We're 3 minutes early. We'll give a minute here for questions, and if we don't have any, we'll sign off and look forward to being on the listserv, seeing each other all in April, and moving from this sort of generic, what's the immigration system look like, to the really more relevant questions for us, which is really how is the state court system involved in immigration, and how does it fit into this, strange framework that we have on the federal side.
And also, I think where the special remedies for kids and for immigrant crime victims kind of fit in, and the roles that Congress has set out for the courts, particularly in those areas.
Good. Well, thank you all very much, and look forward to seeing you in April, and I'm sure we'll have some communications soon before that. So I think we're done.
Yeah. Have a good weekend.
Thank you for joining us.